Okay, good morning. Oh, hello everyone who's already joined us. We're just giving a few more people a minute or two to join us before we get started. And we can see the participant numbers increasing here, but we'll just wait another minute or so and then we'll get started. All right, welcome everyone. We're excited to have all of you with us today. My name is Tracey Epps. I'm the chair of the IPBA International Trade Committee. I'm based at Chapman Tripp, a law firm here in Wellington in New Zealand. My background there is a photo of Wellington. This is our first virtual committee session, and we've got a really great lineup of speakers today, and we'll get started in just a moment. But before we do, I'd like to introduce our president, Jack Lee, to say a few words by way of introduction. Over to you, Jack.
Hello, my dear brothers and sisters, dear distinguished guests. I'm glad to have this opportunity on behalf of Inter-Pacific Bar Association to thank you all of you to join this IPBA webinar at this special moment. COVID-19 virus has been spreading out around the world, but the virus cannot stop our activities for communication. Today, our topic is international trade in a time of crisis. The moderators are Tracey and Jeff. The speakers including Roger, Devin, Nexum, Sansan, and my dear Argentina friend, Augusto. We all know the COVID-19 brings plenty of efforts for global trade. However, through our tireless efforts, the whole world has already controlled the spreading of COVID-19, and the world trade has revived sharply. For instance, the China International Fair for Trade in Service held in Beijing this week. The conference attracted thousands of companies from all over the world. And the third China International Import Expo will be held in Shanghai later this year. Hence, I believe the whole world will back on track quickly. Next April, Shanghai will host 30th Annual Meeting Conference of IPBA. We are looking forward to all of you join with us in Shanghai. Please do not miss this important annual gathering for our IPBA family. Thank you very much.
Thank you very much, President Lee. And before we begin, just a couple of housekeeping items. A couple of our speakers do have slides today, and they'll share them if you would like.
Oh, sorry, I'm trying to get Tracey back.
I think we may have lost her, yes.
Yeah, sorry about that. Oh, where did she go?
Well, let me keep talking while we get Tracey back.
Okay, sorry about that.
No. And on the slides, a couple speakers, as she mentioned, do have slides, and those will be available afterward on request. So if you'd like a copy of the slides, just let us know and we'll make that happen. We also want to make this session as interactive as possible. So we'll have 2 breaks for a Q&A. The first one after the first 3 speakers, and we'll allow panelists to ask each other questions as well as for the audience, obviously, to ask questions. And then at the end, so use the Q&A function at the bottom of your screen to post a question, and we'll work on getting those in as we go along. And there's Tracey back. It's time for
Hi.
you to
Sorry about
turn to
that.
today's panel. I did the housekeeping notes.
Thank you very much, Jeff. Well, this is why we all need to get together in person, because somehow I just got kicked off. So thank you very much, Jeff. So turning now to today's panel, as President Lee has said, we're currently witnessing unprecedented disruptions to international trade and global supply chains. When we met in Singapore back in 2019, we thought that the trade war was really the biggest shift in international trade law and policy in decades. And then along came the pandemic to add to the upheaval. So today's speakers are going to provide us with a variety of perspectives on the current situation, including our speakers from China, Argentina, and the United States. But importantly, our first speaker, Professor Raj Bala, excuse me, is going to provide us with an overview of the global situation. Professor Bala is a professor at the University of Kansas School of Law. He's also a senior advisor at Denton's and their federal regulatory and compliance practice. Professor Bala has published extensively in the field of international trade. His books are nothing short of a Bible for many of us international trade law practitioners. And just very quickly, before he begins, I'd also just like to draw your attention to the column that Professor Bala writes every week or so on Bloomberg Quint website. It's a column on international trade that provides fantastic insights. And this week in particular, he's written on what US trade policy would look like under a Biden-Harris administration, which is particularly relevant to the topic we're considering today. So we will post details so you can access that after this webinar. Over to you now, Raj. Please unmute, Raj.
Thank you very much. It's a delight to be with all of you on the end of this Labor Day weekend from Kansas City. Thank you very much, Tracy and Jeff, for your kind introduction and for organizing this panel. It's really an honor to be here with our colleagues, and I'm actually more interested in hearing and learning from what they have to say. But my job is to set up their presentations. And also special thanks to our president, Jack Lee, for his introductory remarks, and of course to Rhonda Luden in Japan for making all of this possible. International trade in a time of crisis is revolutionary. And in fact, that is the theme and title of my presentation, Contemporary Revolutions in International Trade Law, a matrix of challenges and opportunities. And so what I'd like to do in the next 10 minutes is go through the revolutionary developments in trade since January 2018, but especially in the last roughly 1 year amidst the pandemic. And I'd like to ask the questions, what changes are occurring in the global economy associated with the pandemic and for non-pandemic reasons? How are global economic relationships that have developed and lasted since the Second World War being restructured and disrupted amidst these changes? Now, when I say revolution, I really mean it in the Oxford English Dictionary sense, an alteration, a change, a mutation, a period of significant change or radical alteration of a particular condition, or even the complete overthrow of an established government or social order that had previously reigned. That's the OED definition of what revolution means, and that's what I mean in using the term. Now, international trade law and policy, as we know, operates at three different levels. The multilateral level, that is the GATT and WTO level. It operates at the regional trade agreement or RTA level, free trade agreements and customs unions. And then thirdly, it operates at sort of the bilateral level, where we're talking about bilateral trade relations between, say, the US and Japan, or the US and China, or US and India. And those bilateral relationships are often very much shaped by domestic political pressures. And the bottom line question I'd like to leave us with after going through the presentation is this: are trade, national security, and public health essentially indistinguishable in terms of trade law and policy? Are we now witnessing the equation of trade with national security, with public health, set in the wider context of not only the COVID pandemic, but perhaps a new Cold War? And the answer I would propose, but of course not impose, is yes. So the equivalence of trade, national security, and public health in these changing times of COVID and a possible new Cold War, that's the heart of the revolution that's occurring. Now, what that means is, gone are the days where we can say that trade law and policy is basically driven by the exercise of comparative advantage and the sustained efforts of WTO members to make the world safer for free trade. It's all different now. It's not about David Ricardo and Adam Smith anymore. And likewise, multilateralism, well, it's dead or moribund, at least for now. That equivalence that I'm suggesting also suggests a distinction between robustness and resiliency. And so we'll talk a little bit, if we have a chance, about that important distinction, what's robust and what can be sustained over time, and what's resilient, what can bounce back. Now, in going through the three levels and the revolutionary changes, let's think about three causes for each of the illustrations, each of the types of revolutions that I'm going to suggest. One set of causes of change, of revolution, is directly related to the pandemic, changes that are directly we can link to COVID. A second group of changes are indirectly related to the pandemic. The pandemic may have been a catalyzing force or a complementary variable, but maybe wasn't the key cause. And then finally, there are changes, there are revolutions going on that are utterly unrelated to the pandemic and even sometimes predated them. Now, I leave it to your judgment as to whether you think these causes are all clearly distinct or whether there's some, as econometricians might put, multicollinearity. And I would suggest there is some multicollinearity. Sometimes they're all operating at once and on each other. But basically, what I'd like to leave us with is this framework of three levels and three different types of causes. So, at the multilateral level, what's been directly related to the pandemic? Well, the WTO report on trade barriers against medical goods. That recent report gave examples of personal protective equipment, PPE, and pharmaceuticals that continue to this day to face high tariff and non-tariff barriers. And also continually to this day are characterized by a relatively oligopolistic market. There's a small number of producers of PPE and medical and medicines. That's clearly a development that's directly related to the pandemic, and it's rather shocking when you see the levels of barriers. Indirectly related to the pandemic at the multilateral level, the moribund status of all WTO negotiations, and that's because of a diminution of faith in multilateralism. There's been a resurgence of protectionism, and that's partly due to fears about supply chains for PPE and pharmaceuticals. And some of the other examples we're seeing, nothing's happening in farm trade negotiations, on fishing subsidies, on environmental goods. What about that third cause, unrelated to the pandemic? Well, the appellate body died in December 2019. We've seen the multi-party interim arbitration agreement, the MPIA, take effect. It's plurilateral, Canada's included, US is not, in April 2020. We've also seen some significant WTO appellate body reports. Korea radionuclides, Australia plain packaging. We've seen some significant reports on national security, Russia traffic in transit, and the fascinating new panel report between the Saudis and the Qataris on IP. Those are unrelated to the pandemic, and some of those, I would especially think the Russian and the Saudi cases are rather revolutionary. What about the regional, the FTA level? Well, what we're seeing directly related to the pandemic are efforts to strengthen bonds within certain FTAs. For example, we've seen efforts between Malaysia and Singapore, which of course don't have an FTA, but they're trying to create a travel corridor across the causeway between Johor Bahru and Singapore. Similarly, Australia and New Zealand, under their CER, have talked about a travel bubble to try and help reflate the economy. The post-Brexit EU 27 is trying to ensure their borders are open. Those are all directly related to the pandemic, changes going on within FTAs or customs unions. Indirectly related to the pandemic, we've actually seen some increased barriers within certain FTAs, border closings at the USMCA, possible CPTPP expansion. Now, those are indirectly related. There are other causes, but they also are associated a bit with managing supply chain risk associated with COVID. Unrelated to the pandemic, we saw the USMCA enter into force on the 1st of July. It's got some key provisions that have nothing to do with COVID. Auto rules of origin on regional value content, labor value content, steel and aluminum. We've seen a new labor dispute settlement mechanism. We've seen new developments in the Section 232 steel and aluminum trade wars, including the reimposition of 10% tariffs by the United States on Canadian aluminum. Also unrelated to the pandemic at the FTA level, we've seen post-Brexit FTA negotiations, which may well not come to fruition as between the UK and the EU, given the UK's current position as of today in possibly cutting back on its withdrawal agreement bill. Finally, at the bilateral level, what's been directly related to the pandemic? Well, in Sino-American trade, China cannot, and I would go so far as to say will not be able to meet its purchase agreement targets under the Phase 1 deal because of recession caused by the pandemic and because of the invocation by some Chinese buyers of force majeure clauses in their contracts. We've also seen non-tariff barriers, for example, SPS certifications on the Chinese side of Tyson Foods poultry coming from the United States. Another direct relation to the pandemic at the bilateral level, Japan is providing quote unquote China exit subsidies to companies that are willing to leave China and either come back to Japan or go to Southeast Asia, or as of this weekend or late last week, the Japanese government announced or go to India or Bangladesh. Indirectly related to the pandemic, well, we've seen waves 1, 2, 3, and 4 List A tariffs on Chinese origin merchandise, all an effort to shift supply chains out of China with the longstanding Sino-American trade war, but somewhat related to the pandemic when it comes to PPE and active pharmaceutical ingredients. And a clear linkage then of trade policy to national security and onwards to public health. What about finally unrelated to the pandemic? Well, here we've seen the continuation of the trade war on industrial subsidies, IP misappropriation and cyber theft, state-owned enterprise reform. Those are all non-pandemic related topics that predate the pandemic. We have also seen, unrelated to the pandemic, the revocation of Hong Kong's special trade status, all because of the Chinese Communist Party's national security law that took effect in Hong Kong on the 1st of July, 2020. We have also seen let us say, slide of this trade war into what looks like it's becoming a new Cold War, and we can talk more about that in the questions and answers. Finally, also unrelated to the pandemic, we've seen a tightening of sanctions against Iran by the United States with the atrophying of the JCPOA, the Iran nuclear deal. So to sum up, revolutionary changes at all 3 levels of international trade law policy with 3 different but related causes. Thank you.
Thank you so much for that, Raj. At this point, I was going to introduce Jeff Snyder, our co-moderator today. I think Jeff has already probably had to introduce himself. But just in case he didn't mention, he's a vice chair of the ITC and council. Sorry, I'm just reading Devin's profile, not Jeff's. Jeff is a former chair of the ITC and the JCM for the United States within the IPBA. And Jeff is a partner at Crowell & Mooring in Washington, DC. Jeff is going to introduce our next speaker.
Great, thank you, Tracy. Yes, I have the privilege of introducing our next speaker, Devin Sykes. Devin is Vice Chair of the International Trade Committee and Council at Aiken Gump, Strauss, Hauer and Feld here in Washington. I think temporarily in Houston, or located in Houston, but Devin advises clients on a broad range of international trade issues, and Devin's going to update us on important developments in trade policy, echoing some of what Raj has started under Section 232 and Section 301. Take it away, Devin.
Great. Thanks, Jeff, and thanks, Tracy and President Lee and the IPBA. Hello, everyone. So Professor Bala talked about a few things that I think are really important that will provide a nice segue into what I'd like to discuss with you today, and that is alterations in national security. We have seen a tremendous transformation in that concept over the last couple of years, and in particular, how those concepts are applied under the US statutes in addressing imports that threaten to impair the national security and address unfair trade practices administered by foreign countries, namely China, but there are others. Of course, I'm talking about Section 232 of the Trade Expansion Act of 1962 and Section 301 of the Trade Act of 1974. Under, well, let me just say for a moment that the Trump administration has started a revolution in a way by using these statutes in untraditional ways. And it has resulted in an enormous amount of dispute and litigation, not only here in the US, but with our trading partners abroad. I think there's one sort of consistent theme that we can all see when we think about how the administration has used Section 232 and 301, and that is it's used to gain leverage in trade negotiations. We've seen this time and again since January 2017. Take, for example, the Section 232 duties on steel and aluminum. The administration used that to get Canada and Mexico to agree to certain provisions under what is now USMCA. The administration also initiated a Section 232 investigation into titanium sponge, while at the same time it was trying to negotiate a trade deal, a limited one at that, with Japan. And we also saw this back in 2018 when the administration was trying to negotiate a trade agreement with the EU, when the administration initiated a Section 232 investigation into automobiles and automotive parts. So, what's happened since April 2019? And I pick April 2019 because that was the last time all of us had the good fortune to be in each other's company in person. So let's start with Section 232. Just so we're clear, Section 232 derives its authority from GATT Article 21, and it authorizes the United States to address imports that threaten to impair the national security. What's interesting about Section 232 is under this administration has initiated 8 separate investigations under 232. When you look at the historical use of Section 232, this administration's use of Section 232 accounts for more than 25% of all Section 232 investigations ever conducted. And the 5 investigations that have reached a conclusion, every single one of them have been affirmative. Those investigations have involved steel, aluminum, autos, uranium, titanium sponge, and there are 3 that remain ongoing. What we lovingly call electrical steel in the trade bar, mobile cranes, and vanadium. The administration has also created an exclusion process. Put simply, it's a mess. The exclusions are granted on an importer, a company, and a product-specific basis. And unfortunately, what happens is that there will be different companies importing the same product who are treated differently. and under US law, that is forbidden absent some sort of reasoned explanation for the disparate treatment. So far, the administration has had a difficult time dealing with those issues, particularly in litigation before the US Court of International Trade. There was a decision issued July 2020, in which the court remanded a denied exclusion request to Commerce for further elaboration and consideration. The administration has also taken a few other unusual steps since April 2019. The first was back in January of 2020. It used the original findings from its Section 232 investigation of steel aluminum to cover what we call derivative articles. The administration issued no subsequent investigation supporting why the Section 232 measure should be expanded to the derivative articles, but it nevertheless did so. And not surprisingly, that resulted in an enormous amount of litigation before the Court of International Trade here in the States. As Professor Bala mentioned, the administration also decided to reimpose Section 232 duties on aluminum imports from Canada. There has been, let's just say, healthy debate about whether that move was legal. It would not surprise me to see a challenge result from that move. And of course, there's been even broader litigation on Section 232 itself. There was a lawsuit that challenged Section 232's consistency with the US Constitution. After the Court of International Trade and the Court of Appeals for the Federal Circuit found that Section 232 passed muster, the Supreme Court declined to hear the case. That wasn't too surprising because there is an old Supreme Court case from 1976 called Algonquin, in which the Supreme Court upheld Section 232 against a similar challenge. There also was a case called Trans-Pacific. This resulted from President Trump's decision to double the Section 232 duties on steel imports from Turkey, supposedly because of currency valuation issues, which frankly had nothing to do with the underlying steel investigation. The Court of International Trade, in a series of rulings, first in November 2019 and again in July 2020 on the merits, confirmed that the president's actions were unlawful. Not surprisingly, given how frequent this administration has used Section 232, the government has appealed that decision to the Court of Appeals for the Federal Circuit. So we should expect to hear a decision from the Court of Appeals sometime, let's just say spring next year. There's also, of course, the chance that if a Biden administration assumes office in January, that the Biden administration might decide to dismiss the appeal. But we'll see what happens. So that's Section 232 and national security issues. Let's pivot over to Section 301. Section 301 is the U.S. law, is the law here in the United States that the U.S. Trade Representative has used to carry out the trade war with China. By its own terms, Section 301 is designed to address unfair trade practices or policies that foreign countries administer. Historically, it's been somewhat of a sleepy statute. USTR has used it sparingly, mostly to address intellectual property issues committed by foreign countries. But here again, the administration used Section 301 in an unconventional way. As we all know, this started out as a rather narrow dispute over China's intellectual property practices, and it grew quite substantially from there in April 2018, after the administration announced that the Trump administration announced that it would impose duties on imports whose value equaled roughly 50 billion in US dollars. That led to a series of lists, as Professor Bala mentioned. Those lists covered certain products under the harmonized tariff schedule who were subject to additional duties. Ultimately, there was some hope for progress. And by the end of 2018, there were consistent discussions between the US and China about a potential trade deal. Fast forward to May 2019, shortly after we parted ways in Singapore, and those negotiations completely fell apart. And over the summer of 2019, that resulted in what we know as List 4. USTR broke List 4 up into two parts, 4A and 4B. And the proposed List 4, when combined with Lists 1 through 3, covered nearly every single product that entered the United States from China. Ultimately, in December 2019, the US and China reached the limited Phase 1 trade agreement. And as a result, the proposed List 4 duties were paused, and the duties covered by List 4A were cut in half. Now, USTR has also created its own exclusion process, but to avoid that tricky little issue of treating the similarly situated folks differently, USTR decided to create an exclusion process on a product-specific basis only. Now, for List 3, USTR granted quite a number of exclusions. And what we ultimately learned was that those exclusions were granted not always for merits-based reasons. Sometimes there were connections, there were members of the US Congress who had constituent interests who successfully campaigned the administration for an exclusion. But with respect to List 4, very few exclusions were granted by the administration. And in fact, a number of those exclusions have now lapsed, such that products covered by List 3 and List 4A will now be subject to duties under Section 301. Now, I just briefly want to touch on a few other Section 301 measures that USTR has taken, because the China trade war is not all. You know, again, much like Section 232, this administration has been very aggressive in its use of Section 301. It's used Section 301 to address the European Union's purported failure to address the unfair subsidies that it bestowed to aircraft manufacturers and the European Union. There was a WTO arbitrator who determined in October 2019 that the United States could impose countermeasures worth approximately $7 billion. And not surprisingly, the administration quickly imposed duties on roughly $7.5 billion worth of goods from the EU. USTR has used a carousel approach, and so it has shifted the duties to different products from the EU over a series of different actions between October 2019 and just last month, August 2020. And finally, USTR conducted a Section 301 investigation into the digital services tax that France implemented. And after a rather quick investigation, I believe it was only 4 months, USTR determined that in fact, France's tax was unfair. And in turn, it decided that it would impose duties on roughly $2.4 billion in goods from France. Now, fast forward to July of this year, and USTR decided to delay the imposition of those duties on goods from France while it sought additional information from key industry participants. That delay, that can has been kicked down the road till January 2021. So if the Trump administration wins re-election, it will be very interesting to see what happens. Now, one sort of final thing I want to talk about, and it's quite different from Section 232 and 301, and that's Section 201. This administration has in fact used Section 201. It was the first administration to do so in roughly 16 years to address various solar products and washing machines. But just last month, or I should say actually earlier this month, USTR announced it was going to conduct a safeguard investigation into blueberries. The vast majority of blueberries come to the United States from Chile, Peru, Canada, and Mexico. But USTR also announced that it would seek additional information from industry participants on strawberries and bell peppers. The thinking here is that USTR is going to use the blueberry safeguard case under Section 201 as a test case. And if it works, it's going to potentially pursue relief for strawberries and bell peppers. One of the reasons why the administration pursued this route was that because under anti-dumping and countervailing duty laws, there are seasonality issues that prevent US producers from making a sufficient case for injury and thus securing relief from the US government. that ties it up for me. That's a lot of information. Thanks for your time.
Thank you, Devin. That was a very quick tour, but very interesting, and clearly there's going to be questions to both you and Raj about the next administration and what trade policy might look like, depending on how that goes. But aggressive is definitely the case. Well, let me turn to our next speaker for a perspective from China, Shanshan Xu. Shanshan is a partner at Xianglun in Shanghai, and is a specialist in international trade and customs matters, and increasingly in recent years has been working on export control issues involving U.S. export controls and the impact on companies in China. She's also an adjunct professor in her spare time. She's going to be talking to us about cross-border e-commerce in China. Shanshan? And we have the slides, perfect. Shanshan, you may need to unmute yourself.
Yeah.
Okay.
Can you hear me now? Yeah.
Yep.
Great. Great to share something from China's perspective. Today, I'm going to cover the risks and opportunity for cross-border e-commerce under COVID-19 in China. Next one. Next slide. I'm going to cover two topics. First, the rapid development of cross-border e-commerce since COVID-19. Cross-border e-commerce grows very fast in China. We can see from this slide. Actually, since the overseas outbreak of COVID-19 this year, according to the statistic of China's customs, the import and export of cross-border e-commerce has increased by 26% year-on-year, while the overall China's international trade in goods decreased by 3% over the same period. According to the Early Research Institute, the transaction scale of cross-border e-commerce will reach RMB 12 trillion yuan in 2020, accounting for almost 40% of China's total import and export in goods. The reason is that the online demands goes very high after the outbreak of COVID-19, and this helps the rapid development of cross-border e-commerce and the recovery of China's production for foreign trade. Next one. The definition and the caricature of the cross-border e-commerce. Cross-border e-commerce in China refers to the transaction. Maybe next one. And the next. Yes. Cross-border e-commerce in China refers to the transaction in which the consumer, yes, this one, consumer purchase goods from the seller through the cross-border e-commerce platform on the specific customs supervision mode. And the formal one, slides 6 and 7. We can see the applicable supervision code are 9610 and 1210. The fundamental difference between them is that the goods declared under 9610 have been sold to the consumers, while the goods under 1210 will be stored in bonded warehouse in China for sale. Cross-border e-commerce transaction is characterized by dual nature of both commercial transaction and individual consumption. This particularly applies to importation. Maybe slide 9, I think. First, yes, this one. First, its applicable import tax treatment is favorable than that under traditional mode within the transaction limit. But beyond the limit, there is no tax treatment difference between cross-border e-commerce and the traditional mode of importation. The cross-border e-commerce limit is 5,000 yuan per person and 26,000 yuan per year. Within the limit, the tariff rate is 0, and the VAT and consumption tax payable are temporarily set as like 70% of the statutory tax amount payable. Second, the importation is for buyers' personal use. This is very strictly. The imported goods should be listed on a specified catalog and shall not be resold in the domestic market. The third, imported goods within the limit on the cross-border e-commerce will be supervised as personal belongings. No license, registration, or recording formality required. The fourth, the goods need to be traded through e-commerce transaction platform, which is interconnected with the customs system and allows transaction, payment, and logistic information of goods be compared by customs. The customs will release the goods according to the checklist first, and later on accept the declaration on a summarized basis. Next one. Yes, besides those characterization of e-commerce, cross-border e-commerce, here comes new policies in 2020. In order to reduce the impact of COVID-19, China has introduced a series of new policies to promote the development of cross-border e-commerce. We can see from these slides, first, at the beginning of this year, our State Council has approved 46 new comprehensive test areas for cross-border e-commerce. Now there are 105 of them in total in China. Next one. Yes, goods in this area that meet certain requirements will be exempted from VAT and the consumption tax. Next one. At the end of March, our General Administration of Customs first allowed returning goods from overseas warehouse, and returning to China could be done within 1 year since release. And soon later, GAC declared that the returning of goods imported under cross-border e-commerce could also apply for within 30 days since release, and the buyer's personal transaction limit could be refilled. And the next. Especially in June, our GAC introduced a new code of 9710 and 9810, referred to cross-border e-commerce B2B, cross-border export to overseas warehouse. Maybe next one. Actually, we can see the new regulation responded to the growing demand for overseas warehouses due to the suspension of most international flights. Since B2B is not for personal consumption, the export goods under these two new codes shall go through the inspection and quarantine as traditional way. Next one. Our State Administration of Foreign Exchange also issued a new announcement in May that companies engaging in cross-border e-commerce can offset the cost of warehousing, logistics, taxation, and other expenses by payment of exported goods. The payment received can be inconsistent with the amount at the time of declaration of exportation. Next one. Actually, we see those new policies are quite attractive, but here comes the risk and the challenge to the cross-border e-commerce. First, we can see there's some incompliance risk here, like scalping, which means the importer places orders by collecting and using someone else's ID to meet the limit and enjoy the favorable treatment. And here comes the fourth declaration. The imported goods are not on the cross-border e-commerce catalog, but also be declared as the goods on that. Next one. Besides the non-compliance behavior, here comes more challenges to our customs. For example, the visualized and the flexible supervision brought challenges to them. For example, summarized declaration and return policy may lead to an increase in inconsistent between the documents and the goods. And inspection is very flexible, could also lead to the increase of the quality and the safety risk and the difficulties in preventing the academic risk and the quarantine. So actually we see there are challenges and the chances for China to develop its cross-border e-commerce. Here's my sharing, and I'm waiting for more questions. Thank you.
Thank you, Shanshan. Very interesting. I know there will be some questions from the panelists and from the audience. At this time, we're going to take a Q&A break or a Q&A session. And for those of you who are attending, there are two ways. You can use the chat function at the bottom of your screen, and you can include a question there for the panelists, and also in the Q&A box. In addition, at the bottom of your screen, there is a function to raise your hand. And if you raise your hand, Rhonda, who is watching, will unmute you, and you will be able to ask your question. If you do, please say who, if you want anyone specific to answer your question, or just pose your question. And let me double check to see if any questions have come in yet. No, we're just getting started. So I have a few questions. Augusto, you have a question?
Yes, actually, I can start. Hello, everyone. Maybe a question for Devin. You know that Argentina, it's a double-digit inflation country. You know, we have last year in 2019, we have a 50% annual inflation rate, so it's quite a lot. But we are used to that. So we were a little bit concerned because we heard that the Trump administration was willing to do some research or take a look into the countries that, according to them, could manipulate the currency in order to compete in an unfair manner. So, but then we never heard, we didn't hear anything in that regard. So maybe if Devin would like to comment on this issue of the currency manipulation.
Sure. Thanks for the question. And I should say, buenas, you don't know I speak Spanish, and I actually worked in Argentina for a bit, but more on that later. So the big issue on currency manipulation, at least from the US government perspective, and I think this is where you're going, was in countervailing duty proceedings, also in anti-dumping proceedings. For a long time, there was a question about whether commerce could account for alleged currency manipulations. And in fact, there were statutes floating around about whether to give commerce that authority explicitly. But Commerce just issued a final rule a few months ago that in fact adopted the currency manipulation regulations. And so that is now fair game. And that issue can be alleged in those investigations.
If it's helpful, the phase 1 trade agreement between the United States and China, both sides pledge not to manipulate their respective currencies. They pledge to avoid competitive devaluations and FX manipulation. They've agreed to disclose publicly data on their foreign exchange reserves and their balance of payments positions. Now, 2 days before the phase 1 agreement was published, so January 13th, 2 days before the 15th of January agreement, the US dropped its designation of China as a currency manipulator, which it had designated back in August 2019. The US said it was satisfied with China's commitments in the Phase 1 deal. But critics have pointed out that those pledges are really the same that China made to the group of 20 countries much earlier. And they basically are taken from the USMCA rules on currency manipulation. So let's see where that leads.
Thank you, Raj and Devin. That's great. Shan, if I could, I know there are some questions still coming, but I'm very interested to hear more about the impact of COVID on cross-border e-commerce in China, and especially with respect to food. Is this an issue which has come up?
Thank you. Thanks for the question. Actually, people are very concerned about if they buy some food through the e-commerce and if there are any risk about the food, if there are virus there. Actually, because the inspection is kind of flexible to cross-border e-commerce. However, the frozen food imported through the cross-border e-commerce could only be imported under the code 1210, under which the banded warehouse is required. During their storage in the banded warehouses, the quarantine measures are also required and applicable to those foods. So it's kind of safe.
I see, thank you. And Raj, just a quick question. You gave me some hope when you talked about what's robust versus what's resilient. And I'm really hoping that globalization is resilient because at the moment it doesn't seem too robust.
Agreed.
So that was an easy question, okay. let me check it out.
Put some data to support that hope. Wow, that's a good question that I think I'm temporarily stumped. There's some hopeful data. Let's see. Yeah, no, I share that hope. I mean, we all look at this similar forecasts, and the data are suggesting maybe mid-2021, and we'll see some pickup in volumes and values of trade and economic activity.
And of course, to you and to Devin, that of course depends on the election, I suppose, to some extent.
Yeah, I think the harder question, I think probably the first thing that the Biden administration does on the trade front is roll back the 232 tariffs, because those have been seen broadly as anathema to just about everybody, including the critical allies that the United States has, like Canada and Mexico. I think the harder question is what happens with the China duties. You know, we used to have a country here in the States where one party was free trade, one party was a little more protectionist, and that's, you know, it was easily distinguishable. Now that line is blurred considerably by the rise of populism in the 2010s and to present. That's one of the big reasons why I think the current president is in office. But you know, across the board, you can't be soft on China anymore. It doesn't matter what party you represent, and I think that's going to be around for a while, particularly if, you know, as Professor Bala mentioned, we're at the beginning stages of another Cold War. You know, I just don't see those moving away as easily as maybe something else.
Yeah. And we do have a question from the audience, I think. Rhonda, if you can unmute.
Yep, I sure will. Okay.
So
Randall, yes?
Randall Wilnauer. I'm one of the Professor Bala's students from KU Law. I had this question come up as I was listening to Shan's presentation, but I'd certainly welcome the thoughts of anybody who has an opinion. But in all this talk about, you know, the rise of e-commerce, and we were seeing all this data about how e-commerce was already on the rise before COVID, and certainly it doesn't seem like COVID is going to slow that down any. What you all, maybe your perceptions of how small businesses versus large corporations, how that relationship might change, and how the legal community might respond to some of these changes that we might see.
Thanks for the question. Actually, we all see the trend of the development for cross-border e-commerce. And actually, I think not only the small players are interested in this, actually the platforms always run by the big company like Alibaba in China and Amazon. So not only the small enterprises benefit from the cross-border e-commerce, but also the big ones, I think. Actually, we see the foreign trade numbers are not so bad in China. I think maybe these achievements could large attribute to the development of cross-border e-commerce. To our legal society, I think that's very important for us to make a very active response to this new phenomena of this new type of transaction. To me, I'm practicing the customs law, so I very much care about the new types of violation, new types of compliance for the small players in this kind of transaction, because they don't have very comprehensive, complete system of compliance. So it's very easy for them try to use some way to avoid the tariff they need to pay. Like I said, some people try to collect personal ID to meet the limit to get the favorable treatment. That's a risk of smuggling according to China law. So that's my first step. I think later on, we should focus on more issues, especially legal issues, comes up with this development of cross-border e-commerce. Thank you. That's my answer. Happy to discuss.
Thank you very much.
Yes, thank you. I think I'd love to come back to some of those topics at the later Q&A session, but I think now it's time to turn back to Tracey, who will introduce our next speaker.
Great, thanks, Jeff. We'll turn now, with no further ado, to our fourth speaker, Augusto Vecchio from Argentina. So Augusto co-leads the International Trade and Customs Department at Beca Varela in Buenos Aires. And his practice areas include international trade, WTO rules, Mercosur, and much, much more. So Augusto is going to provide us with a perspective from Latin America. And again, a special thank you to Augusto, because I know it's very late there.
Wow, thank you. Actually, this is the best time because my kids are asleep, you know. I have a 1-year-old kid and a 5-year-old kid. So they're very little ones. Well, I would like to say thanks to Tracey and Jeffrey for inviting me to this wonderful panel. It's great to share this panel with these speakers. I would like to send my warm regards to our President Jack, a very good friend for us. Well, I mean, you know that the topic of this presentation is the impact of COVID-19 on trade. I was asked to provide a perspective. I will do a short perspective from Latin America. I mean, how try to summarize in details, facts, and then some conclusions about the challenges and opportunities. And I will share my presentation. Just let me a second, please, because I am not a millennial. Okay. Okay. So firstly, I would like to address are you seeing is it okay, the presentation? Yes, isn't it? Okay, sorry. I will try to stick to my 10 minutes. So Firstly, to provide some context, some of the global context. I mean, the impact that Latin America is suffering as a consequence of the outbreak of the COVID-19 is in the framework of collapsed global trade. I mean, COVID-19 occurring, the outbreak occurring in a context of sluggish global trade that has been dragging on since the 2008 and 9 financial crisis. The rapid spread of the COVID-19 and the measures adopted by governments to contain it have had a serious consequence for the world's major economies. Many productive activities have been disrupted, first in Asia and then in Europe, North America, and the rest of the world. And there have been widespread border closures. This has resulted in a steep rise in unemployment, with a consequent reduction in the demands for goods and services. In this situation, the volume of global trade in goods fell by almost 18% in last May, compared with the same month in 2019. The drop of the first 5 months of the year was widespread, although it particularly affected exports from the US, Japan, and the European Union. The economic contraction in China was smaller than the global average, because such country controlled the outbreak and reopened its economy relatively quickly. And the Latin American region is unfortunately the most affected developing region. Maybe there are some figures here. You can see the disastrous, the tremendous fall in 2020. And this is a chart that shows the changes in the volume of global trade in percentages. And here, Latin America and the Caribbean is has received the worst hit. Global value chains were the main channel for transmitting the effects of COVID-19 to global trade. The measures adopted by China in January, I mean the temporary closure of the Hubei province and national borders, meant that exports of inputs for industries such as the automotive, electronics, pharmaceutical, and medical supplies were suspended. This forced factories in North America, Europe, and the rest of Asia to shut down for several weeks because they had no alternative suppliers. Since last March, China has gradually reopened its economy and taken steps to normalize exports. However, the initial supply shock on global trade was gradually compounded by a demand shock as the result of the measures to limit the spread of COVID-19 adopted in Europe and later in North America and the rest of the world. The contraction in global trade will be closer to the optimistic end of the projections that range from -13 to -32, depending on how the pandemic evolves during the rest of the year. And also the trading services have been severely affected. Tourism, which accounted for 35% of global exports and services, has been hit particularly hard. Now, we will talk about having said this, having shared these words and these facts and details about the global framework, we will talk about the region. The value of the exports, I mean, the region trading goods has been shocked. The value of exports and imports of goods decreased by 17% between January and May, compared with the same period in 2019. The fall in exports was the result of both a supply shock due to the partial closure of the production and a demand shock that is caused by the recession of the region's main economies. In the case of imports, the decline is largely attributable to the recession of the Latin American economies that will suffer a drop in the GDP that is expected to be more than 9%. The Andean community saw the largest average drop in export value, owing to the high proportion of energy and mining products in its export basket. The value of Mexico's exports plummeted more than 20%. The value of export from the Mercosur, you know that Mercosur is a common customs area that is formed by Argentina, Brazil, Paraguay, and Uruguay. The export from Mercosur decreased more than 12%, but Argentina and Brazil, the largest decreases were in manufacturing exports and, I mean, vehicles, auto parts, chemicals, and fuel shipments. this is mainly as a result of the lower intra-regional demand, because all the manufacturers of these southern cone countries are exported to the Latin American region. However, Brazil and Argentina saw an uptick in their exports of agricultural products, mainly due to the imports of China and other Asian countries. Here you can see the drops. There are some figures. Within the region, exports grew in just 4 countries, all Central American: Costa Rica, Honduras, Guatemala, and Nicaragua. Costa Rica benefited from the increased demand in medical devices to deal with the pandemic, especially in the US. Guatemala and Honduras expanded their export of personal protection equipment, especially face masks and agricultural products, and Nicaragua capitalized on the rise of the price of gold and the volumes of agricultural and livestock products that they export. Between January and May, there were sharp falls in the value of export from Latin America to the US and the European Union, and within the region itself. However, shipments to Asia have shown, as we will see here, has shown greater resilience. In particular, exports to China fell by less than 2% and recovered in April and May. You can see here that China has a 1.2 drop, and then it started to recover and stabilize during April and May. These are the main, as you may see, this is part of the legacy of the COVID-19 pandemic that I am going to talk in the conclusions. But all the manufacturing sectors has well, this is automotive industry, has a significant drop, unlike the agri-industry sector that is still skipping pace, and this shows some of the consequences of COVID-19 that I will discuss in a few minutes. Well, what we expect for the rest of the year. In the first half of the year, regional exports and imports of goods are estimated to have fallen by 17% and 18% respectively. The United Nations Economic Commission for Latin America and the Caribbean projects a 23% contraction in the value of the region exports as a result of declines in both prices and volumes. And for the imports, the expected fall is even larger. I mean, almost maybe a little bit, that 25%. The largest contractions in exports in 2020 are expected in those to the United States and to the region itself, while shipments to China are projected to fall by just 4%. This is a very important detail, because given the structure of the exports to these markets, I mean, mainly exports of manufacturers to the US, like the case of Mexico, and the region, and mainly export of commodities or primary products to China, the consequence of this shock would be the reprimarization of the regional export offer. I mean, you know that Latin America is trying to catch up with the developed world by increasing its export offer of manufacturers, but this, I think that the consequence of the outbreak is that we are going back and putting more emphasis on the exports of primary products that have obviously less added value. Okay, so I will give. Okay, as imports are forecast to fall more than exports, the region is expected to record a trade surplus of over 45 billion in 2020, concentrated in the countries of Mercosur, Chile, and Mexico. The expected trend in regional foreign trade in 2020 suggests there will be a loss of productive capacity in the industrial sector, linked to the sharp contraction in exports of manufacturers and imports of capital goods and intermediate imports. This will make it more difficult to move towards a more knowledge-intensive export specialization as the region emerges from the crisis. So some, I think I have a couple. Just to finish, because I think I have 10 minutes. So Latin America, just maybe share some personal views. Latin America, although having a common past, I mean, all the countries except from Brazil used to be Spanish colonies. We have a common language. We share significant aspects of our culture. But when we talk about trade, we are not as quite integrated as we could be. The Southern Cone countries, I mean, are integrated in Mercosur. Again, Argentina, Brazil, Paraguay, and Uruguay. Bolivia, Ecuador, and Colombia and Peru are members of the Andean community. Mexico is quite integrated to Canada and the US. Chile has a policy of bilateralism with many nations of the world, and the Central American countries are engaged in the Central American Common Market. And also, there are other alliances of importance like the Pacific Alliance, ALADI, or CARICOM, to mention others. No? But anyway, the American continent, I mean the Americas, is divided into different trade blocks, but integration among them could certainly be improved. I mean, this is the opportunity of the post-pandemic, I believe. COVID-19 is changing many of our ways, how we interact with each other, how we work. I mean, this is the first time in my life I am not wearing a tie. So the pandemic is also giving a new opportunity to Latin American nations to think about the future of trade in the region and how we should manage the post-crisis of the pandemic. Although personally, I believe that the way out of the crisis is more trade, multilateralism, and trade based on rules, Latin America could take advantage of the current trends of nearshoring supply, supply and inputs, and developing deeper links within the region. Let's say in a global context of increased production, regionalization, regional integration must play a key role in the crisis recovery strategies in Latin America. Establishing an integrated market of 650 million people could provide the countries of the region with significant protection against external supply or demand shocks. It will also help achieve the scale required to strengthen strategic industries such as pharmaceuticals and medical supplies, and to foster shared production and research networks among countries and subregions. Likewise, more integration means a better position to negotiate with the world's major economies. I mean, given the crucial role of the regional market for manufactured exports and small and medium-sized exporting firms, coordinated action to reactivate intra-regional trade can mitigate the loss of industry and the reprimatization of the productive and export structure that will be the pandemic's legacy in Latin America. Finally, this is just a list of the most popular measures, trade measures that almost every Latin American country adopted to respond to the COVID outbreak. Thank you, and sorry for exceeding my time.
Thank you so much, Augusto. I just have to say really quickly that one of the very first casualties for me, well, here of COVID was when Air New Zealand cancelled its direct flight to Buenos Aires from Auckland here in New Zealand. It was just a sign of a lot worse things that kept coming. So lots to talk about there, but let's now just turn to No Song for Kim, and then we can come back to some Q&A. No Song is an attorney at Page Furrer Law Firm in Chicago, where he advises businesses on all aspects of customs and international trade law. And he also teaches a course in global business. And I understand some of his students may be with us, so welcome. No Song is going to discuss the United States, Mexico, Canada trade agreement. And I will just hand over to you, No Song, for the next 10 minutes or so. Thank you.
Well, thank you very much, Tracy, for the wonderful introduction. Good evening, or morning, wherever you guys are all tuning in from during this very difficult time. As you know well, COVID-19 international trade continues to play a very important role during the pandemic, and many international trade deals continue to occur among many nations despite the initial interruption. And this has been the case with regards to the US-Mexico-Canada agreement, or USMCA, or CUSMA if you're from north of the border, or TMEC if you're from Mexico. The USMCA, as has been mentioned before, was concluded before the outbreak, but it went into force on July 1st, 2020. As a brief historical perspective with regards to the USMCA's origin can be traced back to the late 1980s, when the US and the Canadian government concluded the old US-Canada Free Trade Agreement. In the early 90s, the US began negotiating a similar agreement with the Mexican government at the time that the Mexican government sought to open up its economy. The Canadian government requested to join in that effort, and that led to the creation of Nafta, replacing the old Canada Free Trade Agreement. Now, Nafta went into effect in 1994 with the stated aim to reduce tariffs and other non-tariff barriers, with some tariffs being eliminated immediately and others phasing out over a 15-year period. And then you fast forward 25 years, and then came Trump. During the election, he promised to address and fix trade imbalances among trading partners. And then when he was elected, he threatened to pull out of the agreement, which any member can do by providing the other parties with a 6 months notice. And that led the three governments to agree to renegotiate NAFTA. I think it's important to note that at that time, all three governments essentially agreed that NAFTA needed to be updated. But where the US administration went, however, that was beyond that level. So the agreement was eventually concluded in the fall of 2018. And then through a series of political negotiations and politics, the governments of all three countries ratified the agreement by January 1st of this year. And then, of course, the agreement recently went into force just a few months ago, July 1st, 2020. And I think it's also important to note that when you look at the agreement itself, it doesn't say free or it doesn't say trade at all on the agreement. And the US government has also stated that the USMCA formed the basis for any future free trade agreement that is going to enter into going forward from here. Now, when you look at the text of the agreement itself, the USMCA, you will see that there has been some updates to existing provision. So provisions related to labor rights and environmental standards. You also see that there's been some new elements to the deal, things that were not relevant when the old agreement NAFTA was first negotiated back in '94. So provisions related to e-commerce, which as a result of the pandemic now has come to dominate our lives every single day, as all of us are all tuning in here from using the Zoom platform. There's also some new provisions has been related to dairy with regards to Canadian interests. There's also a provision on a very robust IP protection, which is something the Trump administration cares deeply about, as they've stated that that has been their justification for current trade policy with regards to China. So when you look at the agreement, I think you see that there's been some changes, but the treaty text essentially looks almost like it's 80% NAFTA, and then 20% the Trans-Pacific Partnership, TPP, which the Trump administration pulled out of in its first working day in office back in 2017. So, but again, when you look at the agreement, I think one thing really stands out, and you get the $16 minimum wage floor, which states that at least 40% of cars and 45% of trucks must be made with labor earning at least $16 an hour. And the $16 requirement applies to OEMs and not the suppliers. I think it's also important to note that this is not a 100% labor cost requirement, but a phase-out cap, a phase-in cap that includes credit for research and development, in IT investments, and other such issues such as advanced battery localization. And then you also got the regional value content for rules of origin. As you know well, under NAFTA, if an imported good contained non-NAFTA parts, the importer needed to prove that or show that at least 62% of the content of that product originated from Nafta territory. The USMCA now has raised that percentage to 75% with regards to auto, and then with a different category for components called the core, principal, or complementary parts subject to their own qualifying regional value content requirements. And there's also a provision for 70% originating steel and aluminum sourcing that is applicable to OEMs. Now, one really interesting aspect of the agreement itself includes the so-called opt-out provision, which states that if any of the three countries were to enter into a trade agreement with a non-market economy, they would have to get permission from all three governments. Now, from an implementation standpoint, although much of the compliance aspect of NAFTA remained unchanged under the USMCA, the new agreement does contain some significant changes to the rules of origin of specific industries such as automobiles, pharmaceuticals, chemicals, and cosmetic. So it is important that impacted companies review the rules of origins for their specific product carefully and not assume that because their products qualify under NAFTA, it would also qualify under the USMCA. So companies that operate in the auto sectors, for example, should pay close attention as some of the materials that are incorporated into their finished products may have originated outside of the USMCA region and now must meet the product-specific rules for that specific rules of origin for that specific product that are set out in Annex 4B of the USMCA. I think it's also important to note that they should also refer to General Note 11 of the Harmonized Tariff Schedule of the US as the classifications that are spelled out in much greater details in General Note 11 than they are in the text itself. Another key difference between the two agreements is the documentations that the companies may now use to claim USMCA compliance. So unlike NAFTA, where there was a specific country of origin certification used to certify the product's origin, the USMCA now does not require a specific certificate of origin form per se. Now, the impacted companies must now use the underlying data itself to certify compliance. And that can be done in any manner, including electronically. And the certification must be done by either the importer, the exporter, or the producer. Now, that said, I mean, we would caution, actually not advocate that the importer do a self-certification themselves, because the provision of the USMCA does say that if that is the case, then in doing so, there would be an automatic risk that will be requested by the Importing Customs Administration to provide additional supporting details. And finally, for some products, for example, such as used cars that were entered into a foreign trade zone under privileged foreign status and qualified under NAFTA, but prior to the USMCA going into force, the USMCA does not allow for the grandfathering of such vehicles. So such vehicles would now need to be qualified again under the USMCA rules. And that would essentially apply to repatriation of excess inventory as well. And last, I thought since this is an IPBA event, it would also be important to mention, even if it's in passing, the US-Japan trade agreement, which even though it has nothing to do with USMCA, which is the topic of my presentation. I know, I think Devin mentioned in passing a little bit about that, but it's interesting in the sense that this is only a phase 1 agreement and there are plans for further negotiations. And the interesting thing about this agreement is that there has been some erroneous belief that it is a comprehensive agreement. between the two countries. That's not really the case. The US-Japan Free Trade Agreement is very, very narrow in scope and only covers a few range of classification. It does not have a comprehensive rule or other provisions like you would find in a typical comprehensive free trade agreement. So there is a long way to go before it can truly be called a free trade agreement. And that's it for my presentation, but before I go, I just want to give a quick shout out to my soon to be published book called Trade Crash, a primer on surviving and thriving in pandemics and global trade disruption, which will be published actually early next month, but it goes out for pre-ordering, I guess, next week. So be sure to get some books for me. Thank you.
Put it in the chat. Put the information in the chat.
Oh, I will do that. Thank you.
Okay. Sorry, Tracy.
No, that's a great idea. I was just going to say, I hope that it's going to be published electronically as well. Thank you so much for that, No Song. I mean, we're getting close to time, but I'm sure that we can take an extra 5 minutes for some extra questions. So can I maybe first ask the other panelists if you have any questions you'd like to ask each other, and just encourage the rest of you to please post some questions in the Q&A or chat functions. Do we have any questions, either for Augusto, No Song, or each other? Can I just maybe begin with one question, which is just, it's probably, I don't know, a little controversial, but just one thing I've been seeing in Inside Trade recently is about potential US-Chinese Taipei or Taiwan agreement. Does anyone know what is going on with that? Anyone who can speak to that?
Raj needs to unmute.
It's very much linked to military tensions across the Formosa Strait. The United States is now openly talking about a free trade agreement with Taiwan, which had been bogged down on issues of beef importation by Taiwan, on issues of ractopamine, food additive that is used in the US. When Secretary Azar of Health and Human Services was in Taipei, the Chinese, I think for only the fourth time since 2016, Air Force crossed the midpoint line into Taiwanese airspace, as it were. Each side viewed the other as, being provocative. At roughly the same time, the US declassified the so-called 6 promises that President Reagan had made in 1982 to Taiwan about the security arrangement with Taiwan, and that includes promises about not having an end date on arms sales, and I believe not consulting with Beijing before or on what weapon systems would be sold. And amidst all of this was talk about, serious talk about the US is now thinking about doing an FTA with Taiwan. That arguably would breach a red line with the mainland. If it's perceived to treat Taiwan as an independent country, as opposed to a separate customs territory, the way the US used to treat Hong Kong. But exactly what the status of the negotiations are, I mean, they're very early stages, and if you could even call them that, I don't know.
Thanks, Raj. We have a audience member who would like to ask a question. So I think Rhonda will, Reynaldo, Rhonda, can you, oh yes, we have Reynaldo, you're on.
Okay, guys, can you hear me? Okay,
yes.
That's great. Thank you for the great panel. I have a question the panelists, and it's more directed to Haja and our U.S. colleagues, because we have to be quite more acquainted to U.S. laws and government bodies and institutes for the past few years. We started with CFIUS trying to understand that, how it goes. Actually, PBA colleagues helps us a lot. And now we have the sanctions that being applied from U.S. into a lot of Chinese companies. And what seems to be in the beginning some sort of issue between the two big boys, right? China and U.S. is starting to have impacts all over the world, including here in Latin America. And as like Augusto mentioned, we have Latin America got a lot of trade with China. China has become for the past few years the largest trading partner of several countries, including Brazil and Argentina. And now that the sanctions are dropping up, it's coming up. There's increasing concern in how that would impact the trade and exports between the two countries. And the reason it's also because a lot of the companies in China, there's a large state-owned companies, big conglomerates. We have arms in all kinds of sectors, from construction, or we're dealing with some military issues and agribusiness and also dealing with steel mills. And those guys are usually, some of them are big buyers from Brazilian exporters. I know the guys that export soybean, meat protein, animal protein, and also, iron ore. So the question is, how do we manage that? How can we protect ourselves? So we're starting to have to learn a little bit about these sanctions and what can we do. So I wonder if you have any sort of suggestions or advice into that.
Great, thank you for the question. Who would like to take that one? Someone? Raj? Jeff?
I'm sure Augusto also sharing my questions.
Yes, that's right. I wanted to say, this is for the U.S. practitioners. Hey, guys.
I think here in New Zealand, I'm passionately unqualified to answer it, so I'm looking to our US colleagues here.
I feel like I've talked a lot, so I was really looking forward to hearing our other colleagues on this question, and maybe chime in.
Jeff is just keeping his face down here. He's and muting himself. Jeff, you're muted.
Sorry, no, please, I was writing. Please go ahead, Raj, I'm sorry, or Devin, I'm sorry.
There's a lot to unpack in your question, and I think perhaps the easiest way to answer it is just to say you have to pay close attention, because if this administration gets reelected, things can change quite quickly in a very short amount of time. And there's no real way to forecast this in any sort of predictable way. I can't tell you how many times since January 2017 when I've had conversations with clients and I've had to explain, well, this wouldn't happen because whatever the because was. And the because was based on a long-standing norm. We just can't rely on those norms. So it's about staying informed of the latest developments, understanding the rules. And if you don't understand the rules, asking those who do know the rules. Because as one of my colleagues said recently, this administration has a penchant for dusting off zombie statutes, zombie laws. I think there are some other possibilities and a second Trump term.
I agree with everything that Devin has said, not surprisingly. And, for what little I can add to his excellent answer, if you see what the Japanese and the Indian governments are doing, excuse me, in terms of encouraging the diversification of supply chains out of the mainland, so that Japanese and Indian companies, in fact, multinational companies of all from all jurisdictions, are hedged. Because whether it's a Biden-Harris administration or a Trump-Pence administration, the likelihood of rapid re-engagement with China is pretty low, at least not in the first few years. And we talked about the reasons for that. I think Devin has specifically mentioned some reasons. And so companies want to be anticipating that the trade war will not be resolved anytime soon and could get worse. So they want to diversify their sources. You're seeing Australian companies now look for other export markets, other sources of inputs, etc. So I think to sum up what my little addition to it is, look at what's going on in the likes of Japan, India, and Australia, and some of the other governments that are being proactive to help their companies manage these risks.
Great. Well, thank you. Thank you for that.
Thank you. Look, I realize we are getting close now until almost 40 minutes past the hour. So unless we have any more last minute questions, we should probably wrap up there. So can I just please say thank you, panelists. We really, really appreciate your time today, especially in the evening. And thank you so much also to our audience. We really appreciate you joining us today. And please do keep a lookout for more IPBA webinars. I guess over the next few months, at least, the next years is going to be a bit of a trend. So let's keep joined up, even if we can't be in person for a little while. Although, of course, I hope we can do that sooner rather than later. Jeff, do you want to say anything by way of closing?
Oh, just thank you very much, Tracey, for all your hard work putting this together, and the panelists as well. This has been brave new world. Here we are doing this, but together, and it's so great to see everyone's faces and have you all participate. I only wish we could have the attendees all on Zoom. It would be a huge screen. Thanks to all of you for attending as well. And I hope if you're not a member, as Tracey says, that you'll consider joining the IPBA. There's going to be a lot more to come, a lot more seminars, and especially for US members, there'll be more to talk about at some point soon. Thank you, Tracey. Thank you all. That's all for me.
All right. In that case, have a great day, great evening, and we'll talk to you all soon.
Thank you very much again.
Okay, bye-bye.
Bye.
All right, thank you. Ciao, ciao.
Bye.